Thank you very much for joining us on this extremely rainy evening in Bombay. Let me introduce you to our next speaker, Karishma Vora. Karishma has the rare expertise of being dual qualified. She's qualified in India as well as qualified in England. There are only a handful of lawyers who can profess to have that particular expertise. The top name that comes to mind is Mr. Harish Salve, but that's a matter of time before you get there. Karishma was a litigator at the Bombay Bar until 2009, and then she relocated to London. She now is a busy commercial litigator. She focuses on commercial litigation as well as international arbitrations. She focuses on business and banking disputes. She has the good fortune of appearing before the Privy Council, Court of Appeal, the High Court, county courts, tribunals, as well as courts in India. She's done a lot of work at the Bombay High Court, which I'm aware of personally, as well as arbitrations seated in India as well as in Singapore. As far as institutional arbitration is concerned, she has appeared in institutional arbitration before the LCIA, ICC, UNCITRAL, as well as ad hoc arbitration, which is the order of the day in India as we speak. Interestingly, Karishma not only graduated from the LSE, she has also she's also taught commercial law at the LSE Summer School. So we have an educationist in our midst over here. With that, let me hand it over to Karishma.
Thank you, Sahil. And if it's all right, I would like to address all of you sitting here, as I don't quite have the vertical advantage that Jasbir and Sahil both have.
Okay.
Thank you, Nishith Desai, for having Jasbir and I address this session, and to Sahil and Kshama, who have been excellent and very efficient in arranging our logistics, as well as Charu, who is one of the younger members at NDA, and to Jasbir for accompanying me from London. I am going to speak on the interpretation of jurisdiction clauses. Jurisdiction, and what is a jurisdiction clause? Every dispute needs a form of adjudication, and a jurisdiction clause confers the authority on the forum to adjudicate or hear the dispute. I'd like to speak about the common law position first, which arises out of English law judgments, which the practitioners at the Bombay High Court will know are also applicable to the Bombay High Court. I'll follow that up with a little bit on the European position, and finally end with the Indian position. So to begin with, the common law position on interpretation of jurisdiction clauses. I'll cover the various types of jurisdiction clauses here. The first, and which is the simplest form, is in a one contract case. So where there is just one contract between the parties and one jurisdiction clause within that contract. The default assumption in that case is a one-stop shop jurisdiction, which means that the parties would have intended for all of the disputes to be heard by just one forum rather than dividing it up between a number of forums. I will quote two English judges here. The first is Lord Justice Bingham, who said, "I would be slow to attribute to reasonable parties an intention that there should, in any foreseeable eventuality, be two sets of proceedings." In other words, he would foresee that there would only be one set of proceedings. The second is Lord Hoffman in the very leading case of Fiona Trust. He said, "An assumption that the parties, as rational businessmen, are likely to have intended any dispute is to be heard by the same tribunal." The second type of jurisdiction clause is when there is a series of contracts and there are jurisdiction clauses in each of those contracts, and sometimes those jurisdiction clauses compete with each other or conflict with each other. This is often seen by Indian banks who have lent USD loans, and we have some bankers in the room. And the facility agreement tends to be governed by English law, and courts in England have jurisdiction. But the guarantees sometimes are governed by Indian law because the immovable property tends to be situated in India. And so the guarantees are governed by Indian law and sometimes non-exclusive jurisdiction of the court that has jurisdiction over the immovable property, such as, for example, the Bombay High Court. In these cases, it is better to cast away the presumption of the one-stop shop jurisdiction. The leading English law judgment in this is Satyam Computers. It's the same Satyam Computers that many of us are familiar with. And it was held in that matter that one must look for the jurisdiction clause in the agreement which is at the commercial heart of the commercial center of the transaction. And it would be assumed that that is the jurisdiction that parties would like to confer in the event of a dispute. This also means that there may be ancillary disputes that may arise in different jurisdictions, and that there may be conflicting judgments, but that is something that the parties have agreed to. The next type of jurisdiction clause is jurisdiction clauses in settlement agreements. So when there has already been a dispute between the parties, the dispute has been settled, and there's a settlement agreement which has a jurisdiction clause which says, for example, courts in Mumbai have jurisdiction. The default assumption in such a case is that the dispute resolution clause in the settlement agreement will supersede all of the previous agreements. Then set-offs and counterclaims. Now, in the event of a litigation or a court matter, the court has wide jurisdiction and will be able to hear the counterclaim. This is not so in the case of an arbitration, and what I will speak about mainly concerns arbitrations. There is a twofold consideration. Firstly, whether the counterclaim arises out of the same transaction as the claim that has been brought. And the second is the width of the arbitration clause and whether it is as wide as to incorporate all disputes arising out of. The next topic is parallel litigation and anti-suit injunctions. This is a heavy topic, and I'm going to describe this to begin with from the common law perspective. And when I speak about European law, I will also deal with anti-suit injunctions under European law. From the common law perspective, in my experience, I have often seen one leg of the litigation before now what was the then Company Law Board and the NCLT. So there would be one leg of the litigation ongoing in India, and another leg of the litigation between in the High Court in London or in an arbitration elsewhere. There are four mechanisms of dealing with such parallel litigation. The first rule is that any court, other than the one that is first seized of the matter, should suspend its proceedings. The negative aspect of this is that it may not give effect to the party autonomy. So if the party autonomy has described the second court where the litigation is brought as one that should have had jurisdiction, that will not be affected because the first court will get jurisdiction. The second involves the enforcement of private law rights. This is often seen in family disputes. So for example, in the case of matrimonial disputes between two Indians who may have now acquired citizenship in the UK, there may be the possibility that one of them will bring proceedings in India, in which case India will just have jurisdiction. So the enforcement of private law rights, it might be that a party's bargain is overridden to avoid a multiplicity of proceedings in different jurisdictions. The third is the compulsory recognition of a type of agreement. This tends to be most prevalent in arbitration agreements. So for example, in all New York Convention countries, and India and England are both New York Convention countries, if there is a dispute resolution clause that says the parties will go to arbitration, then a court is obliged to stay its proceedings in favor of the arbitration. The issue that arises here is one of comity, and what happens when one jurisdiction doesn't recognize or does not want to respect another jurisdiction. I have personally been involved in a matter like this almost a decade ago. This was before the Bombay High Court, and Justice Wazifdar was hearing the proceedings. He is now the Chief Justice of the Punjab and Haryana High Court. And he held that in that particular case, given that the English courts had not respected ongoing proceedings before the CLB at that time in India, he would also likewise do what the English court has done. In this case, it resulted in a stalemate, which happens sometimes in parallel litigation. And so we had one court order from England and one from India opposing each other, and a complete stalemate. Things have thankfully progressed greatly since then. And the leading case on this topic is the case of Malhotra and Malhotra. I had the privilege of lifting the anti-suit injunction in this matter in London. What had happened is that there were company law board proceedings between directors and shareholders of Indian companies. And one of the parties went to London and obtained an ex parte anti-suit injunction preventing the Indian CLB proceedings from continuing. They did this on the basis that there was an overarching private equity dispute between the parties, and that dispute contained an arbitration clause. And they argued that this should not have been heard by the CLB and it should have been heard in arbitration. We lifted this in London and were successful in the anti-suit injunction because we were able to prove that this was what is now known as the dressed up argument. So you cannot dress up an argument which may genuinely be a dispute between the shareholders and directors of a company as an arbitration. When this came back to Bombay, Justice Gautam Patel of the Bombay High Court upheld this, and he has also now, through his judgment, brought the dressed up argument within the purview of Indian law. The fourth mechanism of dealing with anti-suit injunctions is simply resisting enforcement. This is the last line of defense. I would not advise this line of defense, but if you find yourself in this situation, it's always better to get declaratory relief from the court that you think has jurisdiction when there are proceedings ongoing in a court or a forum that you think does not have jurisdiction. I now come to the European position. UK is presently a member of the European Union, although we know that this is likely to change fairly shortly. Jurisdiction clauses under the European Union law are governed by two regulations. The first is the Brussels Regulation 1, and the second is Brussels Regulation 2, which is also known as the Brussels Recast. One might think that this is not terribly relevant for Indian parties, but I will elicit an example towards the end where a completely Indian dispute was brought within the ambit of European law. There are basic principles of the Brussels regulations, and these are: the first is that the judgment of a court of one member state is seamlessly enforced without any special procedures in a court in another member state. So unlike the Indian CPC, where one has to convert a foreign judgment into a decree of the court in India and then enforce it in India, that is completely done away with, and enforcement proceedings are seamless between two countries who are members of the European Union. The second general rule is that the defendant must be sued in his or her country of domicile. Again, this is very common and is also under the CPC, that the defendant must be sued in his or her place of residency. The only difference is that the Brussels regulation say that in the event that there is a close connection between the dispute and the party to the proceedings, then that court can have jurisdiction to avoid irreconcilable judgments. And this brings me to my next point, which is avoiding irreconcilable judgments, which is also one of the basic principles of the Brussels regulations. The next is applying the principle that we've discussed previously, which is the court first seized of the matter has jurisdiction over the proceedings, and any second or secondary court will have to stay its proceedings in favor of the court first seized. Now, this is not left to interpretation of national procedural laws. So, for example, Belgium and England and France cannot have its own law about what is the court first seized. The Brussels regulation makes it quite clear, and they say the moment that a document is filed in any court, regardless of whether it's got a lodging number on it, it becomes the court first seized. The last is the protection of a weaker party. So the Brussels regulation recognizes that sometimes there are weaker parties, such as in insurance contracts or consumer contracts or employment contracts, where that party would have had no benefit of being able to argue or change the terms and conditions that he or she is signing. And it confers jurisdiction in favor of the weaker party. Now, all of these principles that I have just discussed are only applicable to litigation and not to arbitration. So specifically, the Brussels regulation says this regulation shall not apply to arbitration. So what happens in the cases of arbitration? And I'm just going to talk to you about a judgment of the Court of Justice of the European Union, which is the highest court and one above the House of Lords in the UK. And it overturned the House of Lords judgment. And I think most of the arbitration practitioners in this room are going to cringe when I elicit this example. But this is the case of the Alliance SPA and West Tankers, in which the Court of Justice of the European Union said that held that anti-suit injunctions restraining proceedings in other EU member state courts issued in support of arbitration were incompatible with the Brussels regulations. This was an attempt was made to amend this in recital 12 of the Brussels recast, which is Brussels Regulation 2. And although that is a step forward, there is still a lot to be done in terms of arbitration. I'm now going to speak a little bit about the English internal conflict of laws and Brexit. The internal conflict of laws rules are governed by Brussels regulations, which I've talked about, and also the Rome regulations. And both of these will be done away with when the UK comes out of the EU. Now, contractual claims are governed by what is called the Rome 1 regulations. When the UK comes out of the EU and Rome 1 falls away, the default position will be that the UK will go back to the Contracts Applicable Law Act 1990. It is expected that this is unlikely to make any significant changes because the Act more or less says what the Rome 1 regulation says. Now, non-contractual cases or cases in tort are governed by the Rome 2 regulations. And in the case of Rome 2, courts where the damage has occurred has jurisdiction. But when this falls away and it goes back to the English position, which is the Private International Law Act 1995, under that act, courts that have jurisdiction are where the events constituting the tort has occurred and not where the damage has occurred. So there's a significant change as far as that is concerned. And Jasbir and I are both a member of ComBar, and ComBar is the Commercial Bar Association in the UK. We've written papers for which we have submitted to the government, and we have suggested in those papers that there must be a change that should be made to the private international law rules for non-contractual or tortious claims. Now, I promised that I would speak to you about an Indian case that was brought within the European law position, and this is the case of ICICI versus Mehta. The names itself give out the Indian connection. In this case, there was a loan default, and ICICI was the bank that was a lender, and there was a father that had personally guaranteed the loan and had passed away, leaving 3 heirs. And because of the personal guarantee, the son and 2 daughters became liable under the loan. The son was resident in Belgium, and by the time the proceedings were brought, the daughters were resident in England. This matter was brought in England, and before I say anything, let me read the jurisdiction clause to you. It says, the courts of Antwerp in Belgium have exclusive jurisdiction. This clause is for the benefit of the lender only. The lender shall not be prevented from taking proceedings relating to a dispute in any number of jurisdictions. So this is what one would commonly know as the non-exclusive jurisdiction clause. And therefore the lender took the advantage and brought the dispute not in the courts in Antwerp, but in the courts in London. We argued that this was not foreseeable at the time that the dispute, that the loan agreement had been signed, and it could not have been foreseen that there would in the future be heirs who would be in London, and therefore courts in London would have jurisdiction. The English court, however, held that where there are a number of defendants, the courts of the country where any of them reside should have jurisdiction, and therefore, given that the sisters were now resident in London, the English courts had jurisdiction. This is what is also called the anchor defendants, because the sisters anchored the proceedings to the courts in England. The English court also held that the brothers' case should also be heard by the English courts and not in Antwerp, because the cases were so closely connected that there was otherwise a risk of irreconcilable judgments. I now come to the final leg of my talk, which is the Indian law position, which is mainly governed by Section 28 of the Indian Contract Act. Now, where there are the CPC says where there are two or more courts that have jurisdiction, parties are able to confer jurisdiction on one of those two courts to the exclusion of the other. But it is not as wide as to say that when a court doesn't have jurisdiction at all, that the parties can choose for that court to have jurisdiction. So, for example, if there's a company in Maharashtra and a company in Tamil Nadu that have a dispute, you cannot have a clause that says the Delhi High Court will have jurisdiction, because otherwise the Delhi High Court doesn't have jurisdiction in the matter at all. The only exception to the rule is the exception set out under Section 28 of the Indian Contract Act, which is in the event of arbitration. So when there is an arbitration clause, then those disputes must be referred to arbitration. And with this, I come to the end of my talk. Thank you.
Thank you, Karishma. Very, very interesting elucidation about interpretation on the jurisdictional aspect of things. Just to add a little bit about the Indian court position. While you're right that the CPC talks about you cannot confer jurisdiction in typically domestic contracts, even though CPC is silent on it, in certain cases, for example, Modi Entertainment, in international contracts, the court has traditionally respected neutral courts being given jurisdiction, especially where there is no party or it has no nexus to any of the parties to a particular dispute. So the concept is certainly there in some case law, but again, only in cross-border contracts, not in strictly domestic agreements. We're now going to open up the lines for any questions that any of our callers may have. As far as people over here are concerned, if you have any questions, happy to take them at this point in time.
Sahil, if I can just add,
of course,
a little bit. I think we now have in India the benefit of the definition of international commercial arbitration under our Arbitration Act, which defines an arbitration between an Indian and at least one non-Indian party as an international commercial arbitration. And for example, Modi Entertainment and other judgments thankfully allow us to confer jurisdiction on foreign courts or courts that would otherwise not have jurisdiction when in the cases of international or cross-border jurisprudence. However, we also have the benefit of Sasan power, and perhaps you'd like to tell the audience a little bit about the domestic Indian arbitrations between two domestic Indian parties where there isn't any foreign party.
Well, there has always been a little bit about a grey area on that particular issue. As far as two Indians are concerned, Section 28 of the Arbitration and Conciliation Act requires them to choose Indian law as a substantive law. Having said that, it doesn't impose any restriction on them from seating their arbitration in a place of their choice. So two Indians could theoretically have an arbitration seated outside the country.
Just to add to that, what Sahil mentioned is that the body of rules that apply in a foreign seat would be applicable to the arbitration that is being conducted by two Indian parties abroad, let's say Singapore. Now that gives rise to certain problems because the lex arbitri will apply. Let's say certain interim measures of protection are required by the parties. Now, although they are subject to Indian jurisdiction because they are Indian parties, however, they've seated the arbitration in Singapore. And the law, or the procedural law of Singapore will apply. Now, let's say if SIAC rules have been chosen, which say that the law of Singapore will apply when the parties have chosen SIAC rules and a foreign seat, which is Singapore. So, in that case, there will always be a conflict between Indian law, including Indian procedural law, and Singapore procedural law. So, as Sahil mentioned, there's still a grey area on whether two Indian parties can choose a foreign seat only because it gives rise to applicability of the lex arbitri, which is the law of the seat to procedure of the arbitration.
Having said that, strictly there is no bar in law to have them seat their arbitration abroad. So, using that argument, they can certainly choose to do so if they...
Yes, I'm involved in an arbitration between two Indian parties who have chosen London as their seat of arbitration, but have chosen to have their governing law as Indian law. And in my view, interpreting the Madhya Pradesh High Court judgment that you've just referred to, I hold and I have advised that these parties can have their seat abroad and be governed by English procedural laws, but the substantive law, as Kshama said, will remain Indian law.
With this, we'd like to call the proceedings to a close. Please feel free to join us for refreshments after this, where you can interact with any of the panelists. But just before that, we'd like to thank Jasbir and Karishma for sharing their valuable time with us. First, Karishma,
Thank you so much. Thank you.
A little something for you.
That's very nice.
Jasbir,
Thank you very much indeed. Thank you very much.
Thank you.
Thank you.